So the topic that we have today is custodial violence. So first and foremost, I have to tell you all that the introduction of the term custodial violence, since we are on a topic of law, the aspect of custody is not defined as such under the Indian laws. There are two aspects where the term custody is used under the law. On the civil side of the law, I think everybody would relate that is the custody of a child. So the child custody, the legal guardian aspect. So therefore, in civil law, the word custody is more or less interchangeably used when it has to denote with the custody of a child in conflict of the law, or a child in a divorce matter. But whereas what we are going to cover today is the custodial aspect of law enforcement agencies or by the custody by the court, whether it is judicial custody or police custody. It could be any agency, whether central agencies like ED, CBI, or any other body, or primarily what we see on a day to day basis, that is the custody that the local police has over a person. So if we are talking about that aspect of local custody, which a local police has over a person whenever there is a crime that takes place locally. And that is what we all would be accustomed to, or we'll be witness to, or we'll be heard about from somebody, who might be detained by the police. So we are talking about the custodial violence that takes place when such a detention takes place by through any of these law enforcement agencies. So now, why does custodial violence take place? So let me get to that aspect. I mean, we all know that custodial violence does take place, but why does it happen? So according to me, in my years of practice and all the things that I've been across and I've seen, theoretical as well as practical, what I see it boils down to three core fundamentals. Why somebody who's detained or is in the custody of the police gets tortured or some violence is inflicted upon them. And what I see there is there are three aspects. One, there could be an aspect of ego involved by the officer who is being detained or under whose instruction the officer detained the so and so person. So one is ego. Then there is an aspect of personal vengeance. Like whoever is holding you in custody, either that officer directly has something towards you, or the complainant who might have registered the false case against you might be influencing the police to, take the vengeance that the complainant has towards you. Or third could be simply to make somebody confess to a crime. Now, under the Indian law, there are several safeguards to prevent conviction by self incrimination. Now, if I am accused of a crime, nobody can rely on the evidence I give to convict my own self. So, there is a law against self incrimination. So, if there is a law against self incrimination and the Indian Evidence Act, which is now Bharatiya Sakshya Samhita, both have extreme safeguard to ensure that any confession or statement that you give to a police officer when in custody is not admissible under the law and cannot be used against you. This is a safeguard that is provided under the Evidence Act, which is now Sakshya Samhita. So, despite that, why do police in most cases, whenever they detain somebody under them, why do they force or inflict violence or torture to get a confession out of somebody? First and foremost, the most easiest explanation is this safeguard that I told you all regarding that confession to a police officer being not admissible is not known to everybody, because the layman's understanding when it comes to the aspect of confession is, if suppose I go and tell the police officer that I committed this crime, then it is but psychological for me to keep saying that at every other forum. So today, if suppose I give a written confession to the police under the fear of the police beating me or the police torturing me, I give them a written statement, though not admissible at that stage. What happens is at the time of framing the charge or at the time of trial, the accused tends to repeat it. And whatever admission that the police got, the same admission is repeated before a judge. Now, that admission that you make before a judge can very well be used to convict you, because then that is a judicial confession, which you confess to a judicial officer. Or if even in police custody, if in the presence of a magistrate you confess to the police and a judicial magistrate is present, then such a confession can also be used against you. So, this aspect, and one more very important part before I miss it, if you confess something to the police, the same Evidence Act says, though the statement that you give against yourself cannot be admissible in a court of law, if your statement leads to a recovery of something, let's just say I'm accused of murder, I'm arrested by the police, and I'm in their custody. The police tortured me, inflicted violence upon me to reveal where the murder weapon is. So now, if I tell the police officer where I've hid the murder weapon, and the police officer goes and traces the murder weapon from that same spot where I gave a statement to that effect, then that particular recovery of the murder weapon can be used against you. So you see how confessing before a police officer, though not directly admissible, can still bear very good fruits if the police officer makes you confess before him. Because it actually helps him a lot in the investigation, overall investigation aspect of the case. So whenever police, especially in a case of theft, which is the most common, or chain snatching, if suppose a thief snatches the chain and later on confesses to the police out of fear of torture or after torture, that the chain that I snatched from this particular woman is at so and so location or at so and so drawer in my home, and that thing chain is recovered from there, then the person is actually can be taken as right action can be taken against him, and he can be convicted by the court of law, because that production of that particular chain, which the investigating agency claims was stolen by this particular man, corroborated with the statement of the victim whose chain was snatched, will ensure that this particular person is convicted. So this is the whole reason why 80 or 90% of the time police inflict some kind of torture on whoever they have detained, so that some kind of confession comes from them, which aids them in the aspect of investigation. So if you all are looking why do police torture, I told you under the three bracket: ego, personal vengeance, or third, simply just to aid them in investigation. Now, I think I don't need to go into the legal aspects of it, but though I'll come back to that later if I feel the need. But there are several safeguards against custodial violence. Simply put, when you are in the custody of a police officer and any torture that happens on you, the police officer will be punished in the same manner as any other third person would detain you. So it is a wrongful confinement. It could be a wrongful restraint. If a violence is inflicted upon you in the form of a hurt, so it can be punishable under penal provisions of inflicting hurt, grievous hurt, attempt to murder. It can be anything. So, depending on the violence that a person has suffered at the hands of the police officer is liable to that very extent how an ordinary man is liable for inflicting pain on anyone. So, the police officers are not above the law. Any agency which detains you, whether legally or illegally, both are bound to ensure that no torture or violence is inflicted upon you. The basic rights goes to this effect by saying that if you are detained, the most fundamental aspect of law that you must be produced before the nearest magistrate within 24 hours of your arrest is to ensure this very same purpose. Because the moment you are produced before the magistrate, the first question that the magistrate will ask, do you have any complaint against the police personnel? Were you beaten? Were you tortured? You have any kind of complaint against the police officer, if you make that to the magistrate is duty bound to ensure that you are safeguarded from that situation and appropriate inquiry is done, and that you get the fruitful result if anything wrong has happened to you. That is why our law has multiple safeguards at several stages to ensure that you do not remain in police custody. The reason why there is only a 14-day period granted for police custody, which is not given upfront also, and the police has to make out a case every 2 3 days, why they want even the maximum period of 14 days to question you under their detention. That is also done with the same motive that the police must not have access to an accused for a long time, so that no torture can happen, so that you an extortion does not take place for a confession. So that is why after police custody, you're immediately taken into judicial custody by the court and you're sent to the nearest jail and you're kept separately as an under trial apart from those convicted in a crime. So that is called judicial custody. So violence does take place under judicial custody also. You might have seen very commonly that even when you are housed in jail, there are so many attacks that fellow inmates do upon you. So that is also a form of custodial violence. So custodial violence is not restricted to the aspect of just police custodial violence, but it can also be the jail custodial violence. Now, therefore, a very important safeguard that comes into this aspect of custodial violence is Actually, let me just point out in such manner that what are the safeguards that you have against custodial violence? What is the way forward? I mean, what do we do? And as part of safeguards, I'm going to come down to the aspect which is very, very crucial, not just in the aspect of custodial violence, but aids in every form of situation whenever we are in a court of law. And that is CCTVs. So, police stations must have CCTVs. Now, the law regarding that and the judicial pronouncement, I'll come back to a little later because that may take some time and I'm going to ensure that you all are completely educated with the real time update as to what is happening on the aspect of CCTV in police station. Before that, what to do as a basic form of precaution. As a layman, as a lawyer, if suppose you're a lawyer, what do you advise to your prospective client or an already existing client as to how to prevent custodial violence? Or as a layman, without the help of a lawyer, if you land up in a situation where you are with the law enforcement agencies and you are afraid of being detained or you are already detained, what can you do as a layman? So I think that's the most important aspect of this entire session with PLEA, so that I'll tell you all how to safeguard yourself. So in the safeguard aspect, there are certain things that you have to do by yourself, and there are certain things if it is already done, you have to point out to the rightful authorities so that necessary action can be taken against the said police personnel or the jail authorities who have inflicted that pain upon you. So the two aspects. So the one is this: what can you do at your own personal level? Most important aspect, uh, if suppose, let's just say, how does it all start? You are one fine day sitting at your home, you receive a call from the nearest police station or any other law enforcement agency, and they inform you on call. They don't say much. I'm telling you the practical experience. They'll just call you, they'll tell कि आपके खिलाफ तकरार है, आप please police station आ जाइए. That's all they're gonna tell. Sometimes they don't even say कि तकरार किसने किया, who has made the complaint. That also they may not reveal. So they may simply tell there is a complaint against you. You please come down to this police station at this particular time. Most of the people fall for this particular time. This is a very, very, very crucial juncture. At this time, you don't know exactly what is the nature of complaint against you. It could be a case of rape against you. It could be a case of murder against you. Whether you have done it or not is a completely different question. But the police officer has said there's a complaint against you. What you must do at this very important point is, first, you must dial back the police officer, or if the call is going on, you must insist on the police officer telling you what is the crime against you, who lodged the complaint against you, when was the complaint lodged against you, and if the complaint was lodged a little earlier, why are you getting a call today and now? And if it's very late in the evening or if it's night, preferably tell the police officer, I'm sorry, at this point of time, I cannot come down. I'll come down first thing in the morning. Why? So that you can gather your thoughts, do a little research of your own, try to tell your relatives, maybe seek a consult a lawyer on an urgent basis, and you inform about the law so that you're better prepared to face the police personnel on the next day when you go to the police station. If the police are refusing to answer these questions as to who is the complainant, what is the nature of the complaint, and they are simply calling you to the police station, then if you're a layman, I would strongly recommend do not go to the police station at that point of time. And this, I don't mean it from an aspect of non cooperating with the investigating agency. I'm just telling you because just like how you are expected to cooperate with the police machinery, the police machinery is also expected to cooperate with you by being transparent and by giving you the complete information. So if they fail to do so, then that means that they are also not operating in a transparent way. And if such is the case, you are well within your rights to ensure that you take appropriate legal counsel and you go down to the police station with a lawyer. Nothing prevents you from taking a lawyer with you. Yes, maybe when you sit down with the police may insist, please ask your lawyer to walk out because there is nothing in the law that says that the lawyer can sit with the complainant or with the accused 24 hours right when the police officer are questioning. So it can happen that the lawyer may be asked to leave for some time, but the lawyer's presence in the police station may make a huge difference. And this is when and let's just say you know the nature of the complaint, it is something very silly. Then, of course, you have an option to cooperate with the investigating agency. Let's just say someone has made a frivolous complaint that you slapped him. Of course, for slapping somebody, ideally you will not be taken into custody because it is not a serious case. It is not a case that is punishable more than 7 years. The reason why I use the term 7 years is because the guidelines issued by the Honorable Supreme Court in the Arnish Kumar case applies very strictly, and there are several directions by the DGP to all the police stations and even by the courts to strictly follow by that. So generally, police officers do not arrest immediately if it is a case that is punishable than less than 7 years, unless there is an issue that there is something pressing that the accused is doing which could land him in trouble immediately, or he may cause further cognizable offenses, or he may abscond. If there are very pressing reasons, only then is the police personnel are supposed to arrest the particular person. Otherwise, they're supposed to be issued a notice under 41A. That was the old CRPC provision. I think it is 35 or something in the new BNS. So the new laws. So, but the structure and the contents of the notice are completely same. The reason though this 41A notice is extremely relevant because whenever the offense is not very serious, or even if let's just say the offense is serious and punishable more than 7 years, just because there exists a power with the police to arrest you does not mean they necessarily have to arrest you. Sometimes there are many financial fraud cases, which could be 409, which is criminal breach of trust, and the punishment is up to 10 years. So the Arnesh Kumar guidelines are applicable strictly till 7 years of imprisonment, but this is 10 years. But still, this is not a crime that involves bodily harm of anybody. It's all financial fraud, which can be proved by paper trails. So in this particular case, also the police can investigate first and then exercise their right to arrest somebody. So sometimes they may just serve a notice upon you, and only if you get the notice, you're advised to go to the said police station. So out of the things that you are supposed to do by your own self is not to rush and be scared when you receive a call from the police or when the police expects you to go to the police station. You can take your time. You are also an individual. You also have your rights. Because if it was extremely urgent, police would have come to your doorstep and arrested you. Because in a case of rape or murder, they are not going to call you for a tea. They're going to come to your doorstep and arrest you because that's the seriousness of the crime. So if the police officer is calling to talk with you to the police station, that means the case against you is most of the time not serious. So you do have time to seek from the police officer that give me time. This is too last minute. I need to take appropriate counsel from my lawyer and then I will come down. Maybe tomorrow or day after or whenever the nearest date is possible. And just to add on a layer of protection for you, you immediately can find out online as to what is the email ID of the police station. You find out the email ID of the police station and you mention in the email ID addressing it to the senior police inspector of the police station that I received a call from so and so police personnel of your police station. I was asked to come to the police station at this time. There was some difficulty and inconvenience that I was facing. Therefore, I cannot be there today. I'm going to come there first thing in the morning. If there is something serious and pressing, kindly give me some information as to why it is pressing and I have to come down right now. This leaves a trail for you to show in the future. Because if the police are going to allege that there was non cooperation from your end, you can very well show this email that I had responded to this particular aspect. So, this is the basic thing that any person can do in case if the police are asking you to come down to the police station. Now, if you are aware about the nature of the complaint, like because nowadays there is a new trend, police do not want to take the trouble of coming down to your doorstep and arresting you. So sometimes they just tell you come to the police station, and the moment you land up in the police station, they arrest you. So basically, you walked into your own grave. So, in order to prevent this kind of a situation, if you know the details of the complaint, or if you have some idea who might have lodged that complaint against you, and if you seriously anticipate that this is going to be a serious issue, could be tortured in the police custody. There could be some violence that could be inflicted upon you. You could be illegally arrested. Any such scenario, and you have the basic details, immediately obtain an anticipatory bail through a lawyer from the sessions court. Immediately obtain an anticipatory bail, and after procuring the anticipatory bail, you go down to the police station. Again, you can drop them an email by stating that I'm afraid to come down to the police station. I think that this could be the complaint. If you have a copy of the complaint, you kindly dispatch it to me because I'm afraid to come before you as you may arrest me. So I'm exercising my right to approach the court of law for an anticipatory bail. And you can stay away for some time. Obtain the anticipatory bail and then cooperate with the investigation if you think that the case against you is false. So this is one of the basic things that you can do. Now, once you let's just say that you could not do the safeguards and you landed up at the police station anyway, and you are at the police station. And like I told you, the most common reason could be personal vengeance, ego, or just to get a confession out of you. You see yourself at the police station, you feel completely stalled, there is nobody to help you. Let's just say the police took away your phone or anything like that. You have to ensure that you tell the police officer that you are an educated individual. Police do not mess with people who they know are educated and are self-aware and they know what to be doing now. So let's just say you've already landed up at the police station. You did not follow the safeguards that I mentioned in step number one, and you are already at step number two, whether you are at the police station and there is a case against you. Now, irrespective about how serious the case may be, the police officers may show it like it is a very serious issue. They may give you an impression that you cannot leave the police station. They will not expressly say that to you. They will say कि आपको अभी क्या करना है बताओ. And this is possibly done to obtain a bribe from you. Or it could be possibly to get a money from the complainant who has registered the case against you. And most people don't know whether they have a right to walk out of the police station or not. Because if there is no FIR and if it was just a complaint and they have not registered an FIR, they cannot hold you for 1 second at the police station. You are at liberty to walk out of the police station next second you're there. And the moment this detail is disclosed to you, that there is no first information report registered against you. So if it is just a written complaint or an oral complaint that somebody has lodged against you, you have to go first to the police station and find out whether the criminal law is set in motion or not, whether an FIR is registered against you or not. Because if there is no FIR, like I told you, police have no authority to detain you. So that's the first thing you confirm if you have already landed up the police station, whether the FIR is against you or not, whether there is any. If there is an FIR against you, you need to find out from the police officer as to under what provision of law, under what sections are the FIR registered against you. What is the nature of the FIR? What are the sections of the FIR? And how much are they punishable for? You yourself can do the research, or mostly if you ask the police officer a question like this, they are duty bound to tell you that. So once they tell you as to under what provision of law is the complaint or the FIR registered against you, then you can gather your thoughts and find out whether it is that serious that they have to hold you or they have to arrest you. So that's the next point that you come down to. As long as you voluntarily participate for some time to ensure that it is done in good spirit towards the complainant who has registered the case or against the inquiry or investigating officer, that is absolutely fine. But if an impression is given to you that it cannot leave the police station, then you have to explicitly ask them, am I under arrest? Because if you are under arrest, the guidelines issued under the CRPC come to your protection because that the police officer is supposed to follow from the moment you are arrested. There has to be an arrest memo that has to be drawn out immediately. Your relative has to be informed. A local panchnama has to be made with a pancha that so and so person was arrested at that particular time. So this gives you a clock, a ticking clock from the knowing very well that you're arrested. Because if you're arrested, you can reach out to your counsel, you can seek appropriate protection so that the same can be arranged for in the form of a bail the next day. And if you are not arrested, you can insist that you be allowed to leave the police station and that you will cooperate continuously with the investigation. I already told you all that if it is an offense which is punishable under 7 years, you have to tell the police officer that I'm aware about the Supreme Court guidelines in Arnesh Kumar case. I will follow the entire case with its citation number to the plea team. You all can obtain, and most of you all will be aware about that judgment. It's a popular and a very landmark case. So if you all tell the police officer that you're aware about your rights and the guidelines issued by the Supreme Court under the Arnesh Kumar case, if it's an offense that is not punishable over than 7 years, you very well have the right to take a notice from the police and leave from the police station and continue to cooperate with the investigating authority. And you can go to the necessary courts to safeguard your interest from a legal point of view with regard to the merits of the case is concerned. But you can very well escape that aspect of custodial impression that you are made to believe that you have to stay in the police station. So you very well can ask these questions to the police officer and you can insist on leaving the police station if it gets uncomfortable for you. As long as you're cooperating out of will, you can always do that. So these are the safeguards that you can do at a personal level. And one very important thing, like I told you, I'll come back to the CCTV aspect. When you are at the police station, let's just say the police are not behaving nice with you. And the moment you landed at the police station, there are many cases that and many instances when such things happen. So you go to the police station, you are treated you're misbehaved very badly, and they abuse you. They sometimes may raise their hand on you, they may slap you. So it becomes quite humiliating, and you get under the pressure that what do I do in a police station filled with police person? What do you do? And yes, that sense of helplessness is well placed Because of course, what he can do, it's not like you can fight an entire police station, and that wouldn't be right as well. So a very important aspect is the CCTVs. Now, there was a judgment of the Honorable Bombay High Court. Do we have a copy of the judgment? You did not take it right now. No, that is clear now. So there was a judgment of the, and I'll come back to my own cases for a very good in-depth insight as to what happens reality and how the courts help you. I'll come back to that later. But there was a case law of the High Court of Bombay, since I'm a lawyer practicing primarily and my parent High Court is Bombay High Court. I'm using that, and there is Supreme Court judgment as well, which I will get back to you all later so that you all can study it well from a legal point of view. Now, there was a judgment of the Honorable Bombay High Court in Leonardo Xavier Varis and others versus Officer in Charge, Vadala Railway Police Station. This is of 2014 and writ petition number 2110 of 2014. Okay. I will forward the judgments for later. So you all do need to make a note of that right now. So in this particular case, it was heard by Justice V.N. Kannade and Justice P.D. Kode back in 2014. And there is a very important part in para 6. So let me just read it out for you all. It was a custodial death case. A young man died in custody. I'm not going in the merits of how he died or what happened. The CBI investigated the matter. You all can read the judgment and understand the facts of the case from that, because I do not wish to go into a particular case details too much. But I'm on the aspect of CCTVs, which are very important for us, the ratio in the case. Para 6 says, we therefore direct the state government to immediately install and maintain closed circuit television CCTV bracket with rotating cameras in every corridor, room, and lockup of each police station, so that every part of the police station is covered 24 hours of the day, and the tapes of the CCTVs shall be preserved for a minimum period of 1 year, and the responsibility of ensuring that CCTV is kept operational shall be on the senior police officer in charge of the police station. Now, you see, this is very, very important, because if every aspect and nook and corner of the police station is covered through by the CCTVs, when you land up in the police station, if there is an abuse or if there is an assault on you by this police personnel, and if the CCTV footages are preserved for a minimum duration of 1 year, then you always can come out of the police station and make out a case, or your kith and kin or your lawyer can always approach the court immediately and tell that the CCTVs of the police station should be preserved and called for. Because in the CCTVs, if you are assaulted by the police, it will be seen. And if the police does not produce the CCTVs, then contempt action can be taken against them for not maintaining of the CCTV. They are very much bound to answer to the Honorable High Court or to their superiors, the senior police inspector of the police station, as the judgment says, that if the CCTVs are not functional, they have to answer as to why they were not functional, and that reason has to be extremely important. And the period for which the CCTVs were not functional, that also has to be explained. So this actually gets the senior police inspector or the station in charge of the police station in deep trouble. So the moment you tell it to the police person that I know my rights, I know that your station should have CCTVs, I know that every corner has to be covered, I know that it has to be covered and maintained for a period of 1 long year. So if you think that today you do it, you delay the matter for some few months and then nothing will happen, no, still you will be called responsible for it. Then the police officer or the police personnel or the people involved at the station is going to think twice before they lay a hand on you. So your awareness can become your greatest friend and the greatest weapon that you have against such people. So if you ever land up in a situation, you must know that there is a High Court judgment, which and the Supreme Court judgment, which citation I'll give later, because the contents are more or less the same. So I'm not going into that case law right now. So once the Supreme Court lays down the law, it is applicable across the country. So it's not just Bombay High Court. Though I read a Bombay High Court judgment, the same contents are reiterated by the Supreme Court in a case law of 2021. This is of 2014. So it is quite recent. So in that, across the country, all the states and the DGPs are directed to ensure that CCTVs are there. So you all can go under the fair assumption that whichever police station you go to, there will be a functioning CCTV. If there is no functioning CCTV, you can simply put a threat to the police that I noticed that there are no CCTVs here, or the CCTVs are not functioning. Do you wish that I take up appropriate action against you for not having the functional CCTVs? So basically, if a threat is made to you, you make a counter threat. So somebody who is aware and somebody who is smart and somebody who is educated, they are not going to mess with you. So, like I told you, before you go to the courts, before your rights are guarded by a judge, or when you invoke the constitution or the statutory rights that you have, it is important to be street smart. In reality, you need to be street smart. You need to appear confident. And that is something that is expected of your own self. A lawyer may not come to rescue at you at that particular point of time. So the first and foremost thing that you do as a preventive measure is to educate yourself. You don't need to be a lawyer. If anybody who is watching this and is not a lawyer, I'm telling you, you don't need to be a lawyer. The things that I'm going to provide you, these judgments and certain things that I'm going to bring it to your light, it's accessible to everybody in the country. You can read, it's plain English, you can educate yourself, and you can ensure that you tell it at the appropriate time if the needs to arise. So these are the steps that you can do from an individual point of view. Now let's just say that still there was some kind of violence against you. It could be recorded in the CCTV, it could not be recorded in the CCTV. Where is the place that you go to? Whom do you file a complaint against? If the police people are the ones responsible for inflicting any kind of harm. At the beginning of the session, I told you all one thing, that a police officer can be punished in the same manner like any other individual can be punished. So the worthy that they wear does not come as a protection to them to do as they please. So whatever action any ordinary man will face, they are also going to face. So the first thing that you can do is, if suppose you are wrongfully restrained, you are illegally detained, if any kind of assault took place, you insist and you write a letter to the senior police inspector of the same station that they register an FIR against their own. Of course, they're not going to do that. Of course, they're not going to do that. I've never had an experience of somebody telling that the police officer registered a case against their own. They never do that. But you are, that's what I told you. You have to be street smart. If it has happened, the first place that you go is the same police station. You go and tell them that you have done this to me. It is my right to register a case, even if it is against you. You please accept my FIR. Of course, they'll say no. They will not give you an acknowledgement if it's a written complaint. Orally, though, you don't stand a chance. So then what do you do? Like I told you all, just so that you have a record and you have a trail to prove it, you immediately write an email. You CC it to the DCP, the Deputy Commissioner of your zone. Since we live in a metropolitan city, I'm just using that as a reference. Or it would be the Senior Superintendent of Police in a rural area. So you keep them as CC and the Commissioner of the concerned place or the DGP of the concerned state as a CC. And in the email, you write all your bad experiences that you have had, or somebody can write for you. If you're detained at that point, you do not have access to your phone, whoever comes to visit you, if it's your relative, tell them to find the email ID online of the concerned police station and let them write that we wish to register an FIR against the concerned so and so police personnel for doing so and so thing. It could be illegal detention, it could be torture in that illegal detention, it could be legal detention but there is still torture. Whatever be the subject matter, ensure that you write an email and you categorically mention in the email that you wish to register an FIR against the concerned police station or against the concerned police person. You email this. So again, as per CRPC, whenever an information or the current Bharatiya Nagari Surasha Sanhita, if they receive the information of a cognizable offense, they have to register an FIR. There's a session that I've done with PLEA on arrest, inquiry, and investigation. So the prevalence sections with which what an FIR is registered, what are the provisions under the BNSS and the CRPC, I have explained it in detail in that particular section. So therefore, I'm not going into the sections and those aspects in this particular session, as it is already covered. So if information of a cognizable offense is received by the concerned police station, and now BNSS also makes a provision for EFIR. So you don't need to even be physically present at the police station to register an FIR. So the moment electronic information is also received by the police station, the police officers are duty bound to register an FIR if a cognizable offense is made out. So therefore, I'm saying that you must very categorically mention what are the experiences that you have been through. If the arrest is illegal, you mention that. If you were beaten in the police station, you have to mention that. And you have to insist on an FIR being registered. So this is the first forum that you go. That is the own police station. Now, if by chance you have done it or you have not done it, there are two authorities which are very, very key in this. One is the Maharashtra State Human Rights Commission. That is for Maharashtra. Of course, every state has its own state human rights commissions. You can approach the state human rights commissions. explain your ordeal or your experiences in detail to the commission. You don't even need a lawyer there. You can go argue your case in person. You have to file a detailed complaint. There is no format as such also for approaching the State Human Rights Commission. It can be a simple letter that you go and file with the commission, and the commission will hear you. The commission has powers to recommend departmental inquiry and necessary action against the concerned police personnel, and also give interim directions to the DGP or the police commissioner concerned to take appropriate action against the police personnel. The easy forum that is to approach without even a lawyer is the State Human Rights Commission. Similarly, there is a something known as a police complaint authority. This is an authority established by the state to specifically deal with complaints regarding police personnel. So if you are a victim of custodial violence or any other aspect of illegality at the hands of the police, you are free to approach the police complaint authority. Again, no particular format as such. You can approach the authority, write a simple letter, your case will be lodged, you will get the lodging number, you can appear in person and argue your case. Ensure that therefore, when you argue your case at a personal capacity also or through a lawyer, this trail that you leave, like the emails that you have written, comes in very, very handy. And whenever you approach this authority, you can always make a prayer that the CCTVs of the police station be preserved and called immediately as an interim relief. That's the first thing you pray. First thing you pray. Even if there is no active functioning CCTV, still you pray for that. Because then they have to give a report to these state human rights commissions or to the police complaint authority that the CCTVs were not functioning. Next, if the third remedy is you can go under the penal provisions, hire a lawyer, you can file a proper private complaint or a case to the magistrate that a direction be given to register an FIR. So you can approach the ordinary court of law against the police personnel under the penal provisions of the penal code. Now it is Bharatiya Nyaya Sanhita. So under the BNS or the older IPC, you can file penal provisions. The sections and all are very easily found. You can just see that, and I will tell that sections to please, so that I'm not going into the aspect of law because it may stretch time. But it is very easily accessible, and you all can find under what penal provisions a police officer can be imprisoned, or action can be taken, or FIR can be registered for his misconduct. So you can go to the ordinary court of law through a lawyer and file a proper private case against him, or a direction that FIR be registered against him through the ordinary court of law. That's the third remedy. Fourth remedy is you can approach the commissioner or the senior superintendent or the deputy commissioner, and you can file a complaint with them stating that your officer of that concerned police station who comes under your jurisdiction has done so and so misconduct against me. I request you to consider initiate appropriate departmental inquiry against this particular officer, and if found guilty, you may suspend him from service or give the appropriate punishment as you may deem fit. So the police officers, the IPS officers at the rank of a deputy commissioner of police or a superintendent of police or anyone above that has the power to launch a departmental inquiry in a particular case against a particular police person. So, if a departmental inquiry is lodged, they have their internal mechanism to find out whether that person has committed the crime or not, the police personnel of whatever station that you are alleging to, and they can be appropriate action can be taken against them by the superior officers. That's the fourth remedy. The fifth remedy is to approach the Honorable High Court under the writ jurisdiction of the High Court. So, under Article 226, you can approach the jurisdictional High Court. If you are somebody in Maharashtra, you can approach the Bombay High Court. And after lodging a complaint or making the DGP or the commissioner party, you can seek very well that a direction be given to them to conduct a departmental inquiry if there is resistance from them in that regard. Same for as you can call for the CCTVs through the High Court, and they're supposed to preserve and furnish the copy of the CCTV to the High Court as well. So basically, you all have five remedies. Five remedies under the law against the police person. I think you all can just rewatch these aspects of five remedies that I've told. Now, coming to the aspect of CCTVs, I discussed this to you all that there is a very good update. This is my personal matter. I will give you all the stamp number if you all wish to follow. It is Gajanan Narayan Khatri versus State of Maharashtra and another. It is writ petition stamp number 945 of 225. It's this year's petition. And so in that, I'm actually fighting for a police constable. A police constable. I'm not going to go into the details of it because laying down my own facts of the case would not be appropriate. But this is something that of public interest and it's a writ petition. So I'm very well, I have the right from my client to disclose this to you all. So this is a writ petition filed by my client who's a police constable. And he has filed it against the station in charge of his own police station. And in this, he alleges that the senior police inspector has let an accused go. He was supposed to be arrested. It was a serious offense. An iron sickle was recovered as a weapon of assault, and there was grievous hurt involved, punishable up to 10 years. And the serious police inspector, because the accused is a relative, let go of that particular person, whoever was involved in that. So in this particular case, he called for the CCTVs of that particular police station because it would prove it right on the point. If the because the accused was in the police station and later let gone without following the law. So on this aspect, he said that the CCTV should be called for. And in this particular case, the senior police inspector also told the person, I mean the complainant who registered the FIR, to take back the case, and they have no such powers to do that. So he was forced to tender an affidavit stating that the information that I've provided, I'm no more interested in pursuing that, and the case be closed. So this case I'm handling myself. So in this particular case, it was the my client has called for the CCTVs of the station, and they said the CCTV has not been functioning for one long year. The Bombay High Court took very serious cognizance of this, and though the Director General of Police of Maharashtra was not a party in the petition, they called for an affidavit from the DGP stating as to what is the status of CCTVs, and if the CCTVs are not functional, whom do we catch, whom do we punish. So, in this particular thing, the Additional Director General of Police Planning and Coordination. So, the department is Additional Director General of Police Planning and Coordination. He filed an affidavit and he stated, and this affidavit I cannot give you all right now because the matter is sub judice, but I am very well within my power to read out a relevant information and it concerns public safety and it is of public interest. It says that I say that this office has issued a circular dated 11/2/2022 to all the concerned units about installation of CCTV system and its standard operating procedure. I further say that in the said circular, it was specifically directed to all the police stations to act strictly as per the earlier office letters dated 21/9/2020, 12/1/2021, 9/3/2021. It is submitted that in the said circular, it is very categorically mentioned at point 3, 8, and 9 that the senior police inspector or officer in charge must ensure proper CCTV video recording is maintained and should submit it when required for investigation or for official purposes. Also, the senior police inspector or officer in charge must report CCTV project components issues to the system integrator and get the same resolved. And if the mentioned activities are not completed in the time, senior police inspector or officer in charge shall be held responsible. So this is a very important disclosure made to the Honorable High Court because the Additional Director General of Police of Maharashtra is stating that we have issued necessary circulars across the police stations in the state, telling them to maintain the CCTVs. If there are issues, it to be resolved in a timely manner. If it is not resolved in a timely manner, or if the CCTVs are not maintained, the senior police inspector of the police stations are liable. So this is very important update that you all should have. The state of Maharashtra admits that they themselves are governing and have issued internal circulars to ensure that the CCTVs are functional. So, if you use this information and you tell a police officer that if the CCTVs are not functioning, this is the law. Your own circulars are to that effect. Your own DGP will take action against you. The police officers will be heavily warned and they will think twice before taking any kind of rash decision against you. Similarly, though the Director General was issued a direction by the 2014 judgment of Leonardo Xavier and several writ petitions that I have given, uh, across the state, they were supposed to file. Yeah, they were supposed to cover all police stations across Maharashtra with CCTVs. However, that has not happened yet. I mean, for reasons best known to them. But there is good progress according to this affidavit. I say that this office has successfully completed the implementation of internal monitoring CCTV projects across all police stations in the year June 2023 in phase wise, hereinafter referred to as project. And since then, the project is under the operations and maintenance phase. The phase 1 and 2 of that project has been completed, and this is the very relevant part, has been completed and 12,305 CCTV cameras have been installed at 1,089 police stations across Maharashtra. So that means 1,089 police stations across Maharashtra have CCTVs. That's a good update. That's a good update. That means there could be many other police stations still not having CCTVs. So, in a manner of speaking, they're in contempt of the Bombay High Court and of the Supreme Court. But we all understand that sometimes the government acts very, very slow, and always running to the court for contempt may not be the wise action. But still, they are in contempt. But apparently, as per this affidavit, efforts are being made to complete all the police stations. So 1,089 police stations across Maharashtra have CCTVs, and 12,305 CCTV cameras have been installed by the Maharashtra state in all these police stations. So, uh, mostly in metropolitan cities, this 1,089 police stations that they claim have CCTV should definitely involve Mumbai, Navi Mumbai, and the metropolitan cities. And most of the cases it come from these cities because people are educated and they report the police whenever there's a wrong thing. So most of the audiences also, I suppose, will be educated individuals. And we must try that more information reaches to the grassroots of issues in rural areas because they may not have this awareness. But as of now, as we all are participating individuals in this aspect, we must be aware to ensure that timely action is taken if wrong is visible to us. Since we are aware, we know the law, we must use this information to ensure that the police do their duty properly. If we all collectively act and we collectively take a stand, there is a high possibility that the police personnel eventually will understand that we cannot just pick somebody up and torture in our custody. There can be grave consequences. So, I think with that, I can say that the session on custodial violence and what can be the possible steps to prevent it, I think I've covered that. Now, I think in the Q&A, Malvika, we can take up if people have any question.
Sir, I would like to ask a question about the
Mhm.
custodial violence that happens inside the prison. So basically,
Okay.
some other inmate does some violence on the fellow inmate, or if the
Mhm.
police by chance just want to inflict some or the other violence on the inmates.
Huh.
Can you tell us a little more about that? You
See, the
said
thing
it,
is,
right? That's also. Huh.
the reason why I did not cover the jail aspect in depth like I did with the police stations is because what happens is this is like a theorem. The aspect of CCTVs which are applicable to be covered in the police station is something to be covered in the jails as well. All these judgments, like they interchangeably use the word police stations as far as jails. So the safeguards that I just covered in my lecture, all the forums that you can approach remain the exact same if the violence takes place in the jail as well. See, in the jail also, the people monitoring you are the police personnel only. Jail is controlled by the police superintendent. So there is a jail superintendent who's also a police officer. There's a jailer who's also a police officer. Whoever monitors the prisoners in a jail is also all our police officers. So the same code of conduct that applies to them in a police station has to be applied in the similar manner in a jail. So in a jail environment, if a fellow inmate attacks you or if the police officer inflicts damage, the CCTVs are supposed to be there as well in every nook and corner.
Right,
So right now, the data that I have is of the police stations. But ideally, there has to be equivalent data for the jail as well, which we all can work together and call for. See, we as
right,
lawyers, we have access based on a case to case basis. The state has all the information, and the state is not going to publish it somewhere publicly so that we all come to know. We have to run behind them to get some information. So something that I think Shruti was the first person who asked the question. So like how she is researching, maybe this is something that you can get on and help me also with, and everybody who
right.
is a participant in this lecture as to what is the status of information of CCTVs in all the jails. Why don't you file an RTI? It will be very, very good if you file an RTA. Something that even my firm can consider. But sometimes what happens is that we get so slushed with work that we do not have time for research sometimes. At least something on the other things which matter to the public. We try to do our best with pro bono cases and stuff like that. But sometimes our hands are tied with going into the research parameters of such magnitude as to what is the status of CCTVs in the jail. So I would much appreciate if you could pursue it. And if you come across any information, you give it to all of us who are the interested parties in this.
We already have a case law on it, DK
Okay.
Basu versus
So DK Basu is
yeah,
something. See, that's the whole point. DK Basu is something that in the which came up in the 90s, if I'm right.
yes.
There has
Huh.
been 3 decades
Somewhere,
after
huh.
that. So
Yes,
3 decades, you see, there has been a huge technological advancement. In 90s, we could not have figured that there has to be CCTVs at every nook and corner. So
correct.
DK Basu has kind of become outdated now. Of course, the safeguards are very important, which you can always use.
Yes.
But whether those safeguards are implemented or not, the aspect of execution and implementation, as per the current standards of technology, needs to be researched right now. You understand what I'm trying to get at? So it's something we collectively have to keep doing in order to get the latest update on this, whether what is being done right now to prevent such an abuse to the inmates.
Okay, sir. Thank you.
You're welcome.
Vinay, Pradeep sir is asking, is there any similar case law for CCTV of all government offices?
Right now, I mean, I'm not aware about an aspect of CCTVs in government offices. Whether there is an aspect of law involved in having CCTVs in government offices becomes a policy matter unless there is an aspect of abuse involved. I mean, I'm not personally aware about a case law where somebody has come and said that there was allegation, because see, sometimes in workplaces sexual harassment and all take place. So they do say that there has to be CCTVs in workplaces, but there is also a counter narrative here by stating that putting CCTVs in a workplace also invades your privacy. So, as from the information that I have, there is a kind of stalemate situation where a CCTV cannot be put on all places of a workplace because it may actually offend people's workspace privacy. If you're constantly monitored by a CCTV when you're sitting at a desk and conducting a job, even though you're a public servant, it may sometimes create an aspect of privacy invasion. But at the same time, if you balance the rights of the individuals concerned, of course, what a public servant is doing in a public building for the service of public can be recorded as well. So I don't see that there is a law currently available either by judicial pronouncement or by government policies, or it could be that I'm personally not aware. That I'm not aware that there is a statutory provision which mandates that there has to be CCTVs at workplace, apart from jails and police stations. But this is something that my firm can look into, or you all can look into and let me.
Okay. Vinay, registration form, there is a question. There were reports of a female advocate being sexually assaulted by the police, and the
Mhm.
Bar Council took no action against this. In such cases, what remedies do we have?
See, the thing is, I don't know why. I mean, see, from a technical point of view, since the female was an advocate, it makes sense to me why you frame the question like that. Ki why is Bar Council not taking an action? Tell me honestly, Bar Council is a statutory body which was made for the welfare of advocates and to ensure that some kind of discipline is imposed on the advocates in performing their duties. It is not a body which can help advocates in safeguarding their rights. Like I told you, don't put it in the form that a female advocate was sexually harassed. A female was sexually harassed. Why should the word advocate make a difference? So does it mean that if an advocate is harassed, it must be taken more seriously? If an ordinary female is harassed, it is not important. See, so therefore, you added the word advocate, so you read in the bar council in it. But ideally, if any female is sexually harassed, as per the POXO Act, sorry, not the POXO, the POSH Act, the Prevention Protection of Women from Sexual Harassment at Workplace Act, that can be invoked if it's a workplace, or as per the penal laws. When a woman is sexually harassed, there are so many safeguards under the penal laws of our country that she can approach the police station and register an FIR against the police. And like I told you, the five remedies that I told you, if the police are to do any wrong, those five remedies can be exercised by anybody. So if she was sexually harassed, she can go and walk into the nearest police station and register an FIR for sexual harassment. Why should she approach the bar council? Because bar council does not have power to punish somebody. It can punish advocates for disciplinary wrongs. But how can the bar council sentence a police officer? Bar council is not a court. So you need to understand the roles of the bar council. A bar council can take internal inquiry and even may aid the advocate in question. But she's a lawyer herself. So she must know that since there are the remedies that I told you which are available against a police officer, she can directly approach the court of law if there is a refusal to register the FIR or do all the other things that I just covered in this particular session as to be what needs to be done against a police officer. So this does this answer that?
Probably question from the registration form that I
No problem, no problem. But I
read
think it
out.
still
Yeah.
answers that. Yeah.
Yes. Vinay, one more like common question in the registration form. Can you shed some
Yeah.
light on evidence, how to gather evidence in such issues? You have covered it, but
So let me, I don't know. Yeah, like you said, I've already covered it. But if I were to just put it in pointers, so that quick pointers for you all. First of all, if suppose if it's custodial violence, you're going to be in a police station filled with police people. they may hardly testify and become your witnesses. If suppose you invoke the future remedies that I told you. So therefore, most of it is preventive. Before you go to the police station, you ensure that you let a couple of people know, or you take some family members to the police station. That can be one. If you are in the police station, like I told you, and there are no family members, and if you're assaulted and something is done, the only remedy as per the current situation is, of course, your word is very, very important. If using the timestamp and the circumstances of your case, the time when you were called at the police station, the time you were kept at the police station, when you left the police station, all these timelines have to be properly noted by you. Because tomorrow these timelines can be given to the court of law to make a circumstantial case that you are right, even if you have no evidence. So the timestamps and the every small act that you do since the time you have entered the police station is very, very important. So just preserving them and remembering them and noting them down can also be a great help for you. That is first. And second, that I told you, even if you do not have evidence, that is the reason CCTVs are there. CCTVs are to be maintained for a period of 1 year. So, in case if suppose today you visited the police station, today you were beaten by the concerned police personnel, immediately write an email and write a complaint to the superior. Do it the very next day, because 1 year the CCTVs have to be preserved. You make a complaint to the police or to the deputy commissioner of police of your zone, or to the commissioner of police of your city, or to the director general of the state. Immediately you put the complaint. You have to get the acknowledgement. If they are refusing to give an acknowledgement, you write an email. After you write an email, file an RTI immediately as to what was the action taken based on the RTI, whether the CCTVs are preserved as per my complaint. So you ensure that the RTI and the complaint is used hand in hand to ensure that the CCTVs are preserved. Because if the CCTVs are preserved, then that becomes your foremost evidence. I mean, it's conclusive, even much beyond a witness testimony, which can be changed or retracted later. But the CCTVs will never lie. So if you force the police personnel themselves to preserve the CCTV, that will go in a long way to act as an evidence for you in no matter which remedy you choose in the future. If the police officers are not preserving the CCTVs, like I told you, approach the police complaint authority and the state human rights or the state human rights commission and ask them to give an interim direction to the police office station concerned to preserve the CCTV. Otherwise, and then if suppose you're assaulted, very, very important. If you're assaulted, if you can show that at the time when you entered you were completely fine, and if you were assaulted and there are marks on your body, any injury marks on your body, immediately go down to the nearest municipal hospital or the state hospital, a local hospital. Don't go to a private institution. Go to a state hospital because they are very much acquainted how to handle a medico legal case. So you moment you walk into a doctor at a government hospital and you tell them I was assaulted, they will immediately make a marking of wherever the injury marks are there on your body, and they will make a medico legal paper stating that the declaration of the patient is that he was assaulted at this police station by this individual, and so on. So are the markings that I've observed, and these are indeed assault marks. So this can be a very crucial evidence, medical evidence. And you can use this paper to see, I will not hurt my own self. I walked into the police station. At this time, there's a call detail record of the police officer calling me. I went to the police station, and 2 hours later, I went to the state hospital to get the medical legal report stating that these are the injury marks on my face or my body. So I think these three aspects of CCTVs, medical report, and the timestamp of events that took place. These three things are enough to prove a case against a police personnel that you were illegally detained or some kind of custodial violence took place on you. I think Malvika, that should answer that.
Yes.
Sir, while
Yeah.
this webinar, you were saying that the police had the authority when the punishment is of 7 years and above, they can directly arrest the person.
They have a discretion.
Just for example, keeping aside the murder and rape cases, forgery is also a severe offense where the punishment is 7 years and above, or threatening
True.
and
True.
whatever.
True. Therefore,
And yeah,
breach of trust has a punishment of up to 10 years, 409.
409 has 10
Yeah.
years breach of trust. So in
Yeah, yeah,
such
10 years.
cases, when
Hmm.
yeah, when in such cases when police don't arrest the accused, then what to do? They in fact help the accused to ask the anticipatory bail before the arrest, and they give them lot of ample time to make the provision for it. Then what to do, sir?
Maybe I'm so sorry, I did not follow your question. What are you saying exactly? Like you're saying that the police does not have an option but to arrest. You're saying like that.
No, 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 just a minute. I will explain it again. If there is a
Okay.
case of breach of trust and
Okay.
forgery, these are
Hmm.
offenses of 7 years and above punishment.
Yes.
When
Yes.
there is an FIR regarding these offences, police don't
Mm,
arrest the accused and help the accused and give them ample time to ask before arrest anticipatory bail. So
mm.
this type of help, when it is provided by police to accused instead of arresting them, then what to do, sir?
So, while Abhi, what I just told about the case that I'm currently dealing with, in which I read that affidavit, did you notice I said that it was a police constable's case against the senior PI of his own police
Yes,
station where an accused was let go in the similar manner so that he can obtain anticipatory bail and he can evade arrest? It's the same thing
yes,
that you just asked. I'm currently dealing with a case of the similar fact that you just told me right now.
yes,
In this particular case also, if such a situation happens, now what you're talking about is not custodial violence at all. You're talking about a police ka dereliction, a general dereliction by the police in not performing their duty. So nobody is harmed here, but somebody is aided because either some bribe could have been given to the police station, police person involved here, or it could be some relative or some other influence on the police to let that particular person walk away, even though that person is accused of a serious crime. So in this also the remedies remain the same. See, if you see the police complaint authority or the state human rights commission or the senior police officers or the Bombay High Court or the actual court of law, all of them there has to be an evidence filed of a misdoing. Anybody commits any crime, they are answerable in the same manner. So there is no exception for the police officer involved here. If you have the documentation to support your theory, what you just said, that the police officer is illegally supporting an accused, you just produce this document before the superior. Or you go to the police complaint authority and you say that the particular person is not doing their duty properly. This is basically a misdoing. This is a misconduct on the aspect of the police officer. So he can be punished and inquired into the same aspect by these five organs, which I already told you are part of the remedies of custodial violence. It's the same file.
yeah. And sir, just now you referred the word bribe. These are
Hmm.
the things we can understand, but we
Hmm.
cannot see with our visual eyes. So in such
Hmm.
cases, na police na intentionally cross question us. How you are taking the name of bribe? Do you have
Therefore,
any?
there is no point. See, there is no point arguing with them. Of course, they will not accept that we took the bribe. So,
Yeah,
therefore,
but
you have to circumstantially gather whatever you have. See, the thing is, let's just say there is an accused punishable who an offense registered against him is punishable by 7 years or upward, like let's just say 10 years. So, this accused was at the police station and he was not arrested by the police. Like I told you, arrest is not mandatory. Arrest is discretionary. If suppose investigation is proceeding properly, the police officer has a discretion to not arrest. Therefore, bail is the rule and jail is the exception. That's the saying that the Supreme Court and the High Court say time and again. No. So you cannot make an allegation against a police person just because they did not arrest somebody because the offense is 7 years and more. No. So the police officers do have a discretion to not arrest. So you cannot file a case against a police officer just because they did not arrest. You have to show that there were enough grounds to arrest and then they did not perform the duties. So if it is bribe, which we cannot prove directly, and nobody gives a bribe in front of your eyes, I agree with you. So you have to go through the circumstances to show that if it is not a bribe, why did the police officer aid the accused? He is answerable to these forums. If he has not taken a bribe, why did they let him go? So catch him like that. You don't need to use the
okay,
word bribe. You can simply
okay,
tell if so and so person was supposed to be detained by you. There were grounds to arrest that so and so person. Despite that grounds, you let the person go. By what
okay,
authority? Why did you let the person go? Let him answer this to the authorities. He will not be able to answer if he has taken a bribe. So he'll be punished in a similar manner. So even
okay,
if you do not have a point to prove bribe or an evidence to prove bribe, you do have the evidence to prove that he committed misconduct, no, in his duty. Focus there.
yes, yes, sir.
That's how you
And sir,
smartly circumvent that aspect.
yes, sir, one more thing related to this. Many a times it happens, FIR is filed, charge sheet is given to the court. Then I wanted to know in the ongoing hearings of the court, even the court orders a warrant against the accused when they are absent or whatever that happens. So in such cases also when the police don't arrest them and they guide the accused go to the court and ask for the bail. So what is the remedy for this also?
So I have faced this in my domestic violence matters where there are several distress warrants issued by the court, but the police will do nothing on that. I have faced
Yes,
this myself in the matters that are currently I'm handling. So in this particular scenario, what I do is If a trial court has issued a warrant and if the police are not sending a report back as to what is the status of the warrant, how did they? They're supposed, so for every warrant, a police officer is duty mandated to submit a report as to what is the execution that they have done based on the warrant of arrest. And if their report is unsatisfactory, let us just say ki, we could not trace them. If it's just a standard, that's the standard reply that they give, that the person was not found at that address or we could not find him. So then this is clearly a dereliction of duty. Police officer is supposed to do more than this if it is an arrest warrant. Like, what are the places that they're going to look? Where, as whether they have done call tracing or they've obtained the CDRs, whether they've traced the location of the accused, whether somebody else's statement, like relatives or somebody, is taken to see where the accused person is. Did they visit the workplace of the accused? They're supposed to give a detailed reply on these aspects. If they do not, you can ask the court which issued the warrant to issue a show cause notice. In my own matters, the courts which have issued warrants have also issued show cause notices to the senior police inspector of the station, asking why contempt action should not be taken against them for not following the court orders. So the court which is issuing warrant has the power to take action against them. So you just file an application that show cause notice be issued against the senior police inspector of that concerned police station, which was supposed to execute the warrant in the proper manner. That's
Yes.
it.
Okay.
Or
Okay.
else,
Okay.
again, you can use the fire remedies. Again, you can use the fire remedies. If there is a dereliction, no matter what kind, you can always approach these five organs and say that the
Writ
police officer is
petitions.
not committing their duty.
Okay. Writ petitions, whichever you are saying, fire remedies for the government
Yeah,
office.
fire remedies are available for any misconduct. Even what you are saying is misconduct. So you can always
Yeah.
go for it.
Yes. Thank you, sir.
You're welcome.
Vinay, last question.
Hmm.
What are the loopholes in the system according to you that the police still has the audacity, despite so many reforms, to indulge into custodial violence?
Too open-ended, too open-ended. I'm wondering where to start to answer that. I mean, I'm so sorry. I mean, I can give a very broad answer to this, like, but again, I don't know where to start. I mean, the entire session was about the loopholes only. How
Yeah,
they actually say that the CCTVs are not functional, or they call you to the police station by stating that complaint hai, they do not maintain transparency. Then once you land up at the police station, they'll arrest you. The biggest loophole. I mean, to summarize, because if I were to give a broad answer, we'll not be able to complete it in time. But the biggest loophole that they use is your lack of awareness. Simply put, it's just our lack of awareness. We don't know what are their powers. Understand the powers of the police. Once you know what their powers are, then you know what they can and they cannot do. If they know that you know their powers, then they're going to be watchful. So the biggest loophole, law mein there is no loophole. They just use it based on circumstances. They just break the law. That is what even what me and Payal were discussing some time back, is that they know the law, but they break the law. So there is not loophole in the law. They don't use loopholes. They just outrightly break the laws with the confidence that you don't know that what your remedies are. That you will not approach those five forums for taking action against them because they're police personals. Think about it for 1 second. If an ordinary person commits a crime against you, you will try to settle the issue then and there. For that also, you don't approach the police station. Imagine going against a police officer. How many of us would dare to do that? Very few people stand up to them. So they go by the simple stature that most of the people are not going to go against them. It is their confidence. So it is our cowardice and inability that empowers them. It is not the loopholes. So there aren't any loophole that I can think of. It is just that if we are not aware and we don't stand up for our rights, they feel empowered that they can do as they please and get away with it. It's as simple as that. So I mean, that is how
agreed.
I would like to answer that question,
So
despite the
legal
legalities.
literacy is the key. Yeah. Okay, Vinay, so I think we are done with the queries. Can we wind up?
Sure, sure, sure.
So thank you so much, Vinay, for such an enlightening webinar. So much clarity on the subject. So thank you.
You're deeply welcome. It's always a pleasure to be with Please.
Okay, bye-bye.
Have a good day,
Thanks
everyone.
again. Bye.
Yes, yes, yes. Have a good day, everyone. Bye. See you.